morning, everyone, and welcome back to our weekly webinar series. Over to Anil, sir.
Thank you, Ankit. Welcome to our 118th webinar, the AAA weekly webinar series. We try to find out the subject which is slightly in kind of focus or in some difficult to understand the concept called feasibility and viability. I am happy to share that I'm complying to do every week. Today, at this moment, I'm actually middle of my golf game at Royal Spring Golf Course at Srinagar. The weather is good here, so you can understand from my golf attire. But yes, I am committed to this weekly webinar series. So we actually would see today, we would see the key provisions under IBC and the regulations regarding feasibility and viability, who is responsible for evaluating and understanding the feasibility and viability of the resolution plan, judicial pronouncements, and then then finally practical aspects of feasibility and viability, which in every case would be different. Depends upon the resolution plan, and the resolution plan, in case the resolution plan is depending upon the revival of the company, revival of the project, and the repayment is proposed out of the cash flow of the revived company, then the feasibility and viability is a very, very difficult job. However, in case of any other case where the payment is being made by the successful resolution applicant out of its own resources, then the committee of creditor has a little softer, easier task to handle. Now, let us understand the where this feasibility and viability word was added. It was added on 23rd of November 2017 by way of an amendment in the IBC. Section 30, subsection 4, where the feasibility and viability for the first time it was actually came into IBC. The subsection 4 of section 30 says the committee of creditors may approve a resolution plan by a vote of not less than 76% of the voting share of the financial creditors after considering its feasibility and viability. So basically the section starts with the committee of creditors. Then it is the responsibility of the committee of creditors to consider feasibility and viability. Then of course the manner of distribution and everything, and also other requirements as may be specified by the board, means IBPI. Now, the section 30 subsection 4 is very clear that it is the responsibility of the committee of creditors to see whether the resolution plan is feasible and viable or not. And this amendment came on 23rd of November 2017. Now, even when we see the approval of resolution plan, which is section 31. Now, adjudicating authorities, let us read section 31 of the IBC. Subsection 1 reads like, if the adjudicating authority is satisfied that the resolution plan as approved by the committee of creditors under subsection 4 of section 30. Now, again, in reference to section 30 subsection 4, meets the requirement as referred to in subsection 2 of section 30. That means the mandatory contents are there in section 30 subsection 2, but the resolution plan has to be approved by the committee of creditors after considering feasibility, viability, and also considering the distribution as mentioned in section 30 subsection 4. And this resolution plan, once approved, if this resolution plan is as per section 30 subsection 4 and as per section 30 subsection 2, then it would be binding on all the stakeholders, including central government, state government, everything is there in the regulation. Then the responsibility was also casted on the IBPI to make regulations about it. So the regulation 38 was made by IBPI, titled as mandatory contents of the resolution plan. Now the sub-regulation 3 says that a resolution plan shall demonstrate that 1, it addresses the cause of default. Number 2, it is feasible and viable. 3, it has provisions for its effective implementation. Then it has provision for approval required and the timeline for the same, and the resolution applicant has the capability to implement the resolution plan. These are the mandatory contents of the resolution plan. So the resolution plan must have the uh, concept of addressing the cause of default, feasible and viable. So in the resolution plan also, the resolution plan must demonstrate how this resolution plan is feasible and viable. Number one, the feasibility and viability. And let's see what exactly comes in Regulation 5 when approval of the resolution plan. So the section 38, the Regulation 38 is the obligation of the resolution applicant. The resolution applicant must consider all these facts: cause of default, feasibility and viability, effective implementation, and what kind of approvals are required, and how the plan would be implemented. That is the responsibility which is the resolution uh, applicant would see, and also the resolution professional also need to see whether the resolution plan is compliant to all the regulations or not. Therefore, the Regulation 38 somehow puts a responsibility on the resolution professional also, that he has to say that the resolution plan which I am presenting before the committee of creditor is also compliant to all the provisions of law or regulations made there under. So therefore, Regulation 38 also to some extent becomes the responsibility of the resolution professional. Primary responsibility lies with the resolution applicant. The resolution professional is also having some responsibility to say that the plan is compliant, but the ultimate responsibility regarding feasibility and viability, whether this plan is feasible or not feasible, that is primarily with the committee of creditors. And then the approval of the resolution plan, finally, the responsibility is completely shifted to committee of creditors when Regulation 39 says the committee shall evaluate the resolution plans received under sub-regulation 2 as per evaluation metrics. B. Record its deliberations on the feasibility and viability of each resolution plan and vote on all such resolution plans simultaneously. So what the regulation says, that the committee shall record its deliberations on the feasibility and viability. One, that the committee must be satisfied about the feasibility and viability. Second, the committee must record its deliberations. That means that in that particular minute, in that particular meeting, the minutes of the meeting must record how the committee of creditors have done the deliberations on the feasibility and viability, and what was the conclusion of those deliberations, whether it was recorded that the plan is feasible and viable or not. So that deliberation has to be recorded in the minutes of the meeting. Otherwise, the resolution plan can be sent back. Otherwise, the resolution plan can be sent back to the committee of creditors for reconsidering all these leftover points. So this kind of amendment, which was made on 23rd of November 2017, this was in fact a very important, where the feasibility and viability was the responsibility of the committee of creditors. Overall, when we see the responsibilities of the committee of creditors regarding the resolution plans, the first is the feasibility and viability, then evaluating the eligibility of the resolution applicant, then also the committee of creditor is also responsible for keeping the company as a going concern, and then the safeguarding the interest of all stakeholders, and then ensuring that the resolution plan provides fair and equitable treatment to operational creditors. That somehow the responsibility that actually goes through the committee of creditors. In some of the judgments where the specifically some text that I could find, it is important that I should say that in some of the judgments, the adjudicating authority, like in the case of Ashika Commercial Private Limited, NCLT Kolkata, in fact, recorded very, very clearly that this is a case in which the COC has judicially distributed the financial bids to the stakeholders according to their full entitlements. There is nothing in the plan to disapprove it. The COC has deliberated well on the two plans, decided the viability, feasibility, and the financial metrics of each plan, and approved one. So similarly, the NCLT Principal Bench, New Delhi, in the case of Common Impacts Private Limited, have also recorded while approving a resolution plan. The decision of the COC is a reasoned and self-speaking one, as required under the provisions of Regulation 39(3). That means that the deliberations was recorded. Therefore, what I'm focusing is that the deliberations on the feasibility and viability has to be recorded there, because this principal bench has also recorded that yes, the this kind of recording is very important. It is actually very important to understand what are the powers of the NCLT and NCLAT. In the case of Arun Kumar Jagat Ramka versus Jindal Steel Private Limited, in fact, the Supreme Court has made following observations on the role of NCLT and NCLAT. So the Supreme Court says that the IBC was introduced in order to overhaul the insolvency and bankruptcy regime in India. As such, it is carefully considered and well thought out piece of legislation which sought to shed away the practices of the past. The legislature has also been working hard to ensure that the efficacy of this legislation remains robust by constantly amending it based on its experience. Consequently, the need for judicial intervention or innovation from the NCLT and NCLAT should be kept at its bare minimum and should not disturb the foundational principles of the IBC. So, what are the judicial intervention? The judicial intervention, it has actually been said in various cases that the committee of creditors, the commercial wisdom of the committee of creditors is supreme. The commercial wisdom also includes the considering the viability and feasibility. So in case the committee of creditor is recording again and again that yes, we are satisfied with the feasibility and viability, then that means the NCLT and NCLAT does not have that power to intervene in the commercial wisdom of the committee of creditors. This was in fact held for the first time by Honorable Supreme Court in case Sashidhar versus Indian Overseas Bank. It was held on 6th of February 2019, where in fact it was basically a combined appeal of two corporate debtors. One was Innovative Industries Limited and other was in Kamineni Steel and Power Private Limited. In one of the case, NCLT rejected, and the other case, NCLAT. So all these appeals finally went to Honorable Supreme Court, and the primary issue in this case was whether the NCLAT correctly upheld the COC's rejection of the resolution plan due to lack of requisite voting power, and the feasibility and viability of the resolution plan should have influenced the COC's decision. Now, one, that the COC rejected, the resolution applicant went for the appeals. Finally, the appeals actually went up to Honorable Supreme Court, and the Honorable Supreme Court finally observed that the commercial wisdom of the Committee of Creditors exercised through its voting is paramount and cannot be challenged by NCLT or NCLAT. The court emphasized that the COC members consisting of financial creditors are best suited to assess the feasibility and viability of a resolution plan. The court further noted that in IBC, a percentage of voting share for the approval of a resolution plan is very important. It further clarified that the judicial review of the COC's decision is limited to ensuring compliances with the procedural requirement of the IBC. Now, the Supreme Court dismissed both the appeals, affirming that the COC's commercial wisdom is conclusive regarding the approval or rejection of the resolution plan. The court underscored that the requirement of voting share is mandatory, and without this threshold, the resolution plans could not be approved. The decision emphasized that the judiciary cannot interfere with the Committee of Creditors' decision-making process regarding the feasibility and viability of the resolution plan. So finally, what K. Sasidaran said. Ankit, am I audible?
Very much, loud and clear.
Okay, very good. So what exactly the Supreme Court says? That the feasibility and viability is part of the commercial wisdom. So the committee of creditor is supreme to understand the committee of creditors. So in this particular webinar, we would be actually deliberating what are the ways that the committee of creditors can look into the feasibility and viability of a resolution plan. So this is the case Asidaran, and we also can say the Supreme Court also, in fact, Ghanshyam Mishra and Sons Private Limited versus Edelweiss, very popular judgment that was delivered on 23rd of April 2019. So in this also, the Odisha Manganese and Mineral Limited, that is the company which was in insolvency, and the committee of creditors, in fact, approved the resolution plan, of Ghanshyam Mishra and Sons Private Limited, and the resolution plan faced objections from Edelweiss. Then the objections, in fact, finally it went to Supreme Court, and the issues between the Supreme Court were, in fact, two or three issues. But the nature of the amendment to Section 31 by 2019 Act, was it clarificatory or substantive? Clarificatory or substantive, that is also, and the resolution plan approval, how the role of the adjudicating authority. So in this case, the Supreme Court observed that once the adjudicating authority approves the resolution plan, it is binding on all stakeholders, including the government. The court emphasized the paramount importance of COC's commercial wisdom in approving or rejecting the resolution plans, limiting judicial review strictly to ensuring compliance with the IBC provisions. The court further highlighted that 2019 amendments to Section 31, which clarifies that the government dues are bound by the resolution plan, is declaratory and clarificatory in nature, reinforcing the existing legal positions. And finally, the decision was that the binding nature of the approved resolution plan on all creditors, including government authorities, that is upheld. It held that any dues not forming part of the resolution plan would stand extinguished. Now, the immediate, like what exactly now we want to say. One important judgment. So these two judgments, and there are many unclear judgments also in the case of Abix Singapore. So there are kind of judgments that we have now seen, which are primarily saying that the committee of creditors' commercial wisdom is supreme. But finally, when we very recently, when we see the judgment of Honorable Supreme Court in the case of Greater Noida Industrial Development Authority versus Prabjit Singh Soni, this judgment was delivered on 12th February 2024, and the name of the corporate debtor is JNC Construction Private Limited. Now, in this case, the Supreme Court says that one of the plots of land acquired by, it was allotted by way of a lease for 90 years to the corporate debtor by charging premium, and also the premium was payable in installments along with some interest. And the right was reserved. Right of the landowner was reserved the right to cancel the lease and resume the demised land subject to certain conditions. This is the first observation of Honorable Supreme Court in this case. Now, in this particular case, the plan which was conceived, it also assumed utilization of the land owned by Noida Authority, Greater Noida Authority. The plan also envisages the use of the land which is not owned by the corporate debtor. It is on lease, and there are provisions in the lease that the lease can be cancelled, of course, with some conditions to be fulfilled. Now, the resolution plan which is approved, that is approved assuming that the land will continue to be with the corporate debtor. It will not be cancelled. So the claim of the Greater Noida Authority was also not admitted, which is a statutory body, and they also have their own rules and regulations. They have a statutory flavor also. So a closer examination of the plan was required. A closer examination of the plan's feasibility and viability was required. So in this particular case, for the first time, the court said that this plan doesn't seem to be viable and feasible because it would not be possible to implement this resolution plan. The moment we the moment we approve this resolution plan, the Greater Noida Authority will cancel the lease. So the land is not owned by the corporate debtor, and then that particular matter will not come to NCLT. It will go to other courts. That means the resolution plan will not be implemented. So therefore, the order of the approval in this case does not envisage such approvals, but neither NCLT nor NCLAT dealt with these aspects. So the court says that the various approvals are required from the Greater Noida Authority. Without those approvals, the construction cannot commence. Without the construction commencement, construction completion, the project would not be implemented and the resolution plan would not be implemented. So that feasibility and viability was not considered by the committee of creditors. So at the time of approving the resolution plan, the adjudicating authority failed to consider whether the plan had made provisions commensurate to appellant's claim and the statutory charge which appellant enjoyed over the assets of the statutory corporate debtor. Statutory charge. So not only that, it overlooked the ownership and statutory rights of the appellant over the land and therefore thereby failed to consider whether the plan was feasible and viable. Therefore, in the absence of such consideration, the order of approvals stood vitiated. Therefore, this plan was sent back. It was sent back to the committee of creditors to finally say that what kind of resolution plan should be prepared so that it becomes feasible and viable. So with this judgment of Greater Noida Authority versus Prabjit Singh Soni, now the feasibility and viability has been triggered. Although it is the commercial wisdom of the committee of creditors, the feasibility viability has to be considered by the committee of creditors. It has to be deliberated by them, but it has to be recorded by them. It has to be recorded and their particular consideration, their decision should be verbal. It should be mentioned somewhere that yes, they have considered. It should be a spoken kind of order. Couple of other considerations that we have seen, although there are various judgments which actually talks about the commercial wisdom, but what we are trying to say today that there are some judgments where we are saying that what exactly we mean by commercial wisdom and what exactly we mean by the feasibility and viability. Now, Ankit, at this stage, do we have some questions? Then I would now move to the practical aspects of feasibility and viability. We have actually, with the judgment of Greater Noida Authority versus Prabjot Singh Soni, this feasibility and viability has been triggered. Now, in various resolution plans, the people who are not happy with the resolution plan, they will come and they will say that this resolution plan is not feasible and viable. In fact, most of the real estate cases are presently coming back to the committee of creditors only because of this issue that the plan is not feasible and viable. Now, if there are questions at this moment, we can take up. Otherwise, I can move to the practical parts of the feasible and viability.
So there's a question which says that can a resolution plan be rejected even when it offers the highest amount to the stakeholders on the basis of not passing the muster of feasibility and viability? And I think we've answered this in positive that yes, there are several instances now where the resolution plans have been sent back to the COC or they have been rejected at NCLT because it was established that the feasibility has not been looked into by the COC or it has kind of been, they escaped the attention, right?
So there are two things into it, Ankit. One is the rejection of the resolution plan, and the other is this sending it back to the COC for reconsidering. So the rejection of the resolution plan means the company goes into liquidation. However, when this goes back to the committee of creditors, that means the process of the resolution process is still continuing. So the resolution plan will be sent back to the committee of creditors for considering the feasibility and viability. So this is not a case that the company will go to liquidation because this is not a case of rejection.
Say that technically it's rejecting the plan, it is sending it back to COC so that the COC can review and reconsider and make sure that the feasibility is taken care of or it is analyzed. And once the COC says that it is feasible and viable, and the COC has a decent basis on of for the same, then of course the NCLT has to pass it, right?
Yeah, basically, like in this particular case, in the case of Greater Noida Authority, everyone was saying, the Committee of Creditors was saying that it is feasible and viable, but the uh, Supreme Court finally observed that there is a very big lacuna in the resolution plan. Without that particular lacuna is plugged, without that, the resolution plan will not be implemented, and also observed that this particular issue has not been considered by NCLT and NCLAT while they have approved the resolution plans or while they have even admitted the appeals. So therefore, the Supreme Court sent it back to the Committee of Creditors rather than NCLT or NCLAT is sending back. So I'm saying, what I'm trying to say is that it is not, we cannot conclude that if again and again committee sends it back to the, if again and again committee sends it back to the NCLT or NCLAT without considering that particular observation, it will again come back. So it is not possible that if the Committee of Creditors again and again say that the resolution plan is viable, feasible, but if the court observation is not complied with, it will again come back to the Committee of Creditors.
So basically, what we're trying to say is that the feasibility and viability is subject to judicial scrutiny at NCLT and NCLAT level. And in case somebody is able to establish, somebody who is maybe opposing the plan is able to establish, maybe it's a creditor, maybe an aggrieved party, that the plan is not viable because of these reasons, which have not been taken into consideration or taken care of by the COC, then the NCLT can send it back.
Yes, yes.
That's what we're talking about. So now I think so there is a possibility that a lot of litigation happens on this issue. So it's become very important for all resolution professionals to take care and ensure that this is taken care of fully, including the concerns that opposing parties might have with respect to the viability and feasibility. So that becomes very important.
Yes.
Um, so then if a resolution plan proposes, I think this is already taken care of. In case of a real estate company, if full dues of local authorities are not settled, can they interfere with the future construction and projects? I think it's not a like. So I think the question is that if somebody's dues are not fully settled in a resolution plan, can they say this is not feasible? Can they say this is not
No, see, it is
because
not.
here
No, it is not something that the NCLT doesn't have power. NCLT and NCLAT, they have power to direct an authority that your claim has been admitted by the RP. Your claim has been admitted as secured operational creditor as directed in the case of Greater Noida Authority versus Prabjeet Soni. According to this, under Section 53, a particular amount is due to you as per waterfall arrangement, maybe 50%, maybe 60%. That is provided in the resolution plan. Now, in case you are getting this, then why would you hold the permissions? Why would you hold the renewals? Why would you hold the approval of the building plans? That can be. There is the powers are with NCLT, NCLAT, Supreme Court. They have certainly powers. But the only thing is that they must see that the resolution plan is compliant. Resolution plan have considered the statutory authority according to the law. Resolution plan have given their dues in the resolution plan as per Section 53 by considering them as uh, secured operational creditors. And if that is done, then I'm not saying that the full amount has to be paid. Even the secured financial creditors are not getting full amount. So the secured creditor will be pari passu, may it be operational creditor or financial creditor. So whatever they are getting, 50%, 60%, with that, the statutory authority like Noida or Greater Noida, they should be satisfied. And then the court will have the power to direct them to give all the permissions and cooperate with the resolution process.
Then we have a question from Mr. Lalit Maheshwari. He says that if resolution plan couldn't pass due to lack of required voting percentage, that is 66%, but 65% of COC considers that this plan is beneficial for majority of stakeholders. Can RP have an option to put before NCLT that this plan is good for majority of the shareholders rather than liquidation of the CD? I don't think the
Not even one,
RP,
not
yeah,
even
not
one
though.
judgment is available because it's at the with this. 66%, which used to be 75% earlier, is sacrosanct, and not even a fraction of a percentage actually would be permitted. So there is nobody who actually can say that yes, it is about 75% or it is about 66%, so we can approve the resolution plan. That is not the power which is available with anyone, including Honorable Supreme Court. I'm sorry to say that, but that is something which is not the power as per law, as per IBC. But they can use their own other powers. That is something different.
I think we can move forward.
So, like, say, Ankit, like coming in case we try to see there are some few judgments that we have seen, especially in the case of Sukhbir Singh, ex-director of Maple Realcon Private Limited versus Dinesh Chandra Agarwal, the resolution professional of Maple Realcon Private Limited. In this particular case, NCLAT New Delhi, in fact, held, it's a long back, it's like September 2019, it was held that the feasibility and viability is not applicable on settlement proposals under Section 12A. In fact, under Section 12A also, feasibility and viability is seen by the creditors in case there is some deferred payment as per the settlement agreement, or there are some amount which is full payable after the approval of the resolution plan, and the uh, committee of creditor has not seen the sources of fund. So, but the court says once uh, the feasibility and viability concept is not applicable to any kind of settlement proposal under Section 12A of the IBC. So this is one judgment which is important.
So I think there's a technical issue, but what I will do is I will try and talk about the topic at my end. So I believe that we were, of course, discussing and maybe we have him back a while back. So we were talking about the various decisions, and I believe that I can share a little bit about the recent decisions that came in. I can start with so basically what we wanted to say was that when a bank evaluates a loan application for a new project, so we want to understand now that what is the feasibility analysis that is done at other instances other than how the resolution, what is done at the resolution plan approval stage, so that it helps us bring in a comparison that this is what we do at that stage when we are understanding the feasibility. So I think we have him back.
So the
You can continue now. Yeah, yeah.
difficulty I faced today because of the direct sun, the mobile phone,
Heat it up.
and then it
Oh,
was supposed to be cooled up before it starts
oh,
working.
oh. Yeah, yeah, yeah.
And now I have put this in a shadow of a tree, and now I'm actually I can. But in case there are some questions, so what I in fact was saying that in the case of Aducom Solutions and in the case of Aston Field Solars, it is it was finally argued that because of the uh, time that has actually lapsed, and now it is not even possible to implement the resolution plan, the viability and the feasibility has actually adversely impacted. So in this case, like uh, the very commercial basis of the approval of the resolution plan is eroded by the subsequent events, say a natural calamity that destroys the only asset of the corporate debtor. So the successful resolution applicant will not be permitted to withdraw or modify the plan, even if it runs the risk of facing penal consequences under Section 74 of the Code for its unavoidable failure to implement the plan. So according to my understanding, this Educom Solutions and Aston Field, which is when it says that the resolution plan cannot be allowed to be withdrawn, it cannot be allowed to be modified. My understanding is that the better option with that person would be to face the penal consequences under Section 74 in case the resolution plan is not viable, it is not feasible because of any kind of natural calamity, any kind of events post approval of the resolution plan by the COC. Therefore, this particular the judgments are present. You see, even of late, I have seen that in many cases, of late, I have seen in many cases, the resolution plans are now modified after the approval of the resolution, after the approval of the committee of creditors. The resolution plans are being modified because of the delay, because of the increase in the cost of construction, and NCLT has considered those things in the resolution plan, and some kind of option was given to the committee to reconsider the viability and feasibility. And as claimed by the resolution applicant, then the plan is not viable now. So it has actually been given to the committee of creditors that you can consider what he says, and you can provide for some kind of escalation in the cost of construction. Those kind of things I have seen. Now, the resolution plan cannot be withdrawn even if the feasibility and viability is adversely impacted because of the events subsequent to the approval by COC, is also kind of discouraging to these applicants. So therefore, the courts have started taking a lenient view now on this. The EDUCOM is not completely being implemented. It's not being applied on other cases. So the are to be assessed. Now, when this particular judgment in the case of EDUCOM, it was in fact said that the feasibility and viability of a resolution plan are to be assessed at the stage of the approval by the COC and not at a later stage. If at the stage of the approval, the resolution plan was viable and feasible, and then not later on. Therefore, the approval by the COC time, that is important. So the like again in various cases, the tribunal NCLAT has many times has been held that the approval of the resolution plan by the committee of creditor inherently suggests that its feasibility and viability has been considered, and the courts are not supposed to interfere with the commercial decision. The uh, the like even in one case, it has been held by the NCLT that even if the resolution plan proposes the change of the business model, even if the resolution plan is proposing that the uh, new products will be introduced, or a new kind of business will be started on the same land, that also the feasibility and viability is the job of the committee of creditors. Even if there is a change in the business model, if the committee of creditors accept that, the courts are not supposed to interfere into this. So therefore, regarding the feasibility and viability, the final decision lies with the court. But because of this Prabjot Singh Soni case, the it is now open to the courts to understand the feasibility and viability, and they can even send this resolution plan back to the committee of creditors. Now, let us understand what is the feasibility and viability. So there are we can divide the resolution plans into in two kind of variants. One variant of a resolution plan is that the amount is being paid upfront and it is not directly linked to the revenues out of the corporate debtors revived business model. And the second variant is that the revival of the plan, revival of the business, that is the key for making repayment to the creditors. So in the first part, the business projections are not really very important. The business projections are not really very important. The what is important then? The importance is that uh, the source of funds. So the source of funds are available. The credibility of the resolution applicant, the past experience about the resolution applicant, the credit rating of the applicant. So in case all this is acceptable, so that means that the repayment will be done, even if the company is not able to revive its business. So that is the one variant of the resolution plan. So in these kind of resolution plans, the job of the committee of creditors is little much easier. But in case of other variant, where the project would be revived, the project revenues would actually be seen in the projections. The profitability would be seen in the projections. Then the out of the profitability, the repayment will be made to the creditors. So in that case, the feasibility viability is just like assessing a new loan proposal, making an assessment about the viability of the project and feasibility of the project, feasibility of the achievability of the projections. That is something which is just equivalent to making a kind of appraisal of a loan proposal. Appraisal of a loan proposal, that is important. So this is the one part. Now, in case, let us try to see, there are some projects where the feasibility and viability is uh, depending upon kind of one or two things. Like in the case of say thermal powers. In case a resolution plan says that the thermal power plant will be revived and out of the revenues the amount will be paid, and the committee say that there is no coal linkages, there is no power purchase agreement, and there is no water availability. So how the project will be revived and how the revenues will come, that is not certain. So therefore, committee will say that it is not feasible and viable. So in the case of suppose on airlines, if a resolution plan says that it will be a kind of a resolution plan and the airlines will be operational and it will be the revenues will actually be so much and the profitability will be so much, and out of this the repayment of the loans will be made. However, the license to operate an airlines, if that is missing and there is no certainty of availability of the license, so these kind of resolution plans are considered as not feasible and viable, but rather the NCLT or Supreme Court can even direct the authorities to grant them the license to operate in case they invest funds, in case they are technically eligible. So that kind of directions can be made. So Ankit, at this kind of scenario, what exactly are the questions? Because see, now we are almost done. Because see, like when I say the feasibility and viability, that is just like understanding and deliberating on a project feasibility. When we consider the project feasibility, we also try to see the business plan. The business plan must include market analysis, the business model, revenue streams, growth projections. Technical feasibility is like technology, equipment, process involved. So market analysis like the demand analysis, competition, market share, potential for growth. So when we see the financial viability is the projected financial statements, income statement, balance sheet, and the cash flow, capital structure, how much equity from promoters, how much equity is coming from the resolution applicant. So then the profitability ratios and then the cash flow analysis for the future. Then the resolution applicant's background, resolution applicant's experience, and their past history, how much performance security they are offering, how much collateral security they are offering, whether they are offering personal guarantee or corporate guarantee or not, what kind of regulatory compliances are required, whether those compliances will be available, whether the building plan will be renewed, whether the slum rehabilitation authority would actually give them the approvals and renewals, will they get all kind of licenses, permits. So see whether they the kind of inflow that we project out of the arbitration litigations, whether that is feasible or not, and what kind of risk analysis that the committee of creditors can see, what kind of economic cycles that particular business of the corporate debtor is subject to, and what kind of prepayment capacity. All this, Ankit, has to be seen by the committee of creditors. Is just like appraising a loan proposal. However, there are some compulsions with the creditors when they are already stuck up. So they will have to make some compromises. And even if some issues are not fully compliant, then I believe the committee of creditors still approve the or accept the feasibility and viability of the resolution plans. So, Ankit, this is what I wanted to say about the kind of the feasibility and viability. How the committee of creditors will have to be very, very careful. How the committee of creditors will have to be make a very, very spoken deliberations, and also how they have considered even the uh, adjudicating authority has started asking very, very direct questions about feasibility and viability. We can take up some practical questions in case of any kind of resolution plan. We can say, yes, the committee of creditors will have to see this kind of issues while deliberating on the feasibility and viability.
So we have a question from the question is that can suspended management question the feasibility on genuine grounds? And I think yes, you've answered this as yes. And then we look at the question that if RP engages any marketing consultant to assess feasibility, whether it can be included in CRP cost, there is a possibility that the RP can go to COC, or the COC can say that, okay, let's appoint a TV consultant or somebody who wants to independently assess the feasibility of a resolution plan. It is possible, but it is not the norm per se, but it is
It
possible.
is possible because I would not see that in case the committee of creditors approve a kind appointment of a consultant, the committee of creditors approve their fee. It is a part of the process. It is
Mhm.
not something that they're doing for themselves. The duty of the RP is also to make some kind of comments on the feasibility and viability. So for making these comments a kind of techno viability study or a market survey, that if is required, and I think it is still can be part of the CIRP cost.
Yeah, it can make especially where COC is feeling that this can be a contention for passing the resolution plan. I think it's a good step to kind of tell the NCLT also that we have this in place. We have two raised hands. One is from Mr. Sanjeev Bindal and the other is from Mr. Himanshu Kapadia. I am asking them to speak and share their question. In case they can, Himanshu ji, Sanjeev ji can unmute themselves, we can then hear them out.
Yeah, can you hear me, sir?
We can, Himanshu ji.
So, Anilji, I have a question. Then, when we draft the resolution plan as a professional, and if there are non-compliance like Companies Act non-compliance of the corporate debtor and various other act non-compliance, how the resolution plan should dealt with?
No, all the past non-compliances before the commencement of CIRP that we normally seek waiver, and the registrar of companies have also come out with those kind of notifications and circulars where all these non-compliances can be regularized. Uh, then the GNL 2 can be filed rather than filing all the past balance sheets. So resolution plan can always say that all the past obligations on the non-compliances of the Companies Act that would be waived, and all the penalties can be waived, and the ROC will accept our financial statements and our all documents from the current period without even connecting it with the past. Those kind of things are possible. Of course, the ROC is doing it in a pick and choose manner because this is not something they have developed a process. So for everything which is regular, they have developed a process. So this is something which is not a regular thing for them. So somebody has to go there personally to convince them that this is a company in insolvency. So the past, all the past liabilities of penalty or late filing fee, that will be waived.
Same thing will be applicable for stock exchange non-compliance, etc. also.
Stock exchange also have come up with their regulations time and again, and any kind of past non-compliances, their penalties, all they will file their claims, and that will be dealt with under Section 53. However, for resolution applicant, is something which after the takeover of the company, all the compliances has to be regularized, and then the company can be relisted also. So all these penalties can be part of the waivers and the kind of reliefs.
Thank you, sir. So we can incorporate in the resolution plan whatever non-compliance in, and we can request the authority. It will not be part of the non-feasibility. It is possible.
No, it is not kind
Feasibility
of
feasibility is not a connection, or is not connected with past compliances at all. I believe that it is just a procedural requirement. So in case I'm giving you some examples, let's say the company has not filed the ITRs for the past 2 3 years. Now the resolution applicant and the SRA during the monitoring committee meetings can say that this non-filing of previous ITRs might cause a problem to me, and I'm willing to file these returns. And maybe somebody will bear the cost, maybe the SRA, or the professional cost of making those ITRs. Similarly, ROC related compliances can be completed. Similarly, maybe a company has not been audited for the past 4 years. So those processes can be completed. So normally an SRA would seek these compliances to be completed in coordination with the resolution professional and complete it, because he wants to run the company as a going concern in case something comes up tomorrow that these pendencies will haunt him in the future. So normally SRA would get this done from the, or get this done with professionals and the resolution professional. But feasibility and viability of the plan is normally not connected with past compliances. That's a business plan issue, that how will the revenue come from, who will fund it and all that.
Right. Thank you, sir.
Then,
Actually, my question was that, many times all this non-compliance can create a huge penalty prosecution at a later date, and that may affect the feasibility of the plan. And that is why, I was concerning and correlating with the feasibility. Sometimes we cannot ascertain. And as a professional RP, many times it happens that we will not be able to complete the process because we don't have the data, information, etc.
No, I think you're right. So
So,
we have answers. The answer is that all the penalties and all kind of non-compliances will come under the reliefs and concessions.
right. Okay. Good.
Yes.
Yeah.
so
Thank you, sir.
Sanjeev ji,
Thank you very much, sir.
Thank you.
Sanjeev ji and Ranjan ji, in case you would want to unmute yourself.
Yes, please.
I think I did something wrong, my bad. Yeah, maybe now Ranjan ji can speak.
Am I audible now?
Yeah,
Yes,
you
yes.
are.
Conditional resolution plan can be approved by CFC and NCLT, and if so, how much would be the conditions?
No, I think this was the first case when this Jet Airways resolution plan was approved. And in that resolution plan, it was a condition that in case the government will not give me the license to operate an airlines in India, then this resolution plan would not be, then I would not be under obligation to implement this resolution plan. Similarly, a conditional plan where somebody can say that if the Noida Authority or Greater Noida Authority would not be settled, or in case then I would not be. So these kind of conditions. So the first and the only resolution plan which has been admitted, because in that case, the basic key factor of the resolution plan was the license to operate an airlines. So that is the only resolution plan which has been admitted so far as a conditional resolution plan. So based on that, if a resolution applicant see that one particular condition or one particular event is very, very important for resolving, then the resolution plan can be conditional to that extent. So, but then not many conditional plans are seen as approved by the Committee of Creditors. The Committee of Creditors are putting their foot down that not to approve a resolution plan which is conditional. So in the case of Jet Airlines, the Committee of Creditors also approved a conditional plan. However, in the case of other cases, the Committee of Creditors they are saying that we are okay to liquidate the company rather than approving a conditional resolution plan, because the uncertainty is difficult for them rather than certainty.
So there is a question that if there is a brought forward losses, or let's say the non-filing of ITRs has happened and brought forward losses are not claimable as per the income tax provisions, can somebody say in the resolution plan that okay, these are old returns and under this the benefit should be available to the company, and seek that benefit of carry forward losses in the resolution plan? So I believe
No
here
such,
yeah,
no
I
such
have
reliefs
not
or
seen that.
concessions can be
One
seen.
can even put this in the resolution plan, but normally the NCLT order will simply say that any concessions with respect to income tax liability will be subject to the approval of the principal commissioner, and that is how it is worded in the Income Tax Act also, that it will be subject to scrutiny by the income tax officer, even if such a claim has been made. Then I believe we've taken care of all the questions. I don't see any new questions per se. If
I think
uh,
we can conclude the
yeah,
feasibility and
Sanjeev ji,
viability.
I think Sanjeev ji wants to say something.
Good morning, sir. I have a question.
Please go ahead, sir.
In one of my matters, I received two resolution plans. One resolution plan was declared ineligible on the ground of eligibility criteria. In RFRP, we put a eligibility criteria of rupees 8 crores. While submitting the resolution plan, the suspended director submitted a net worth certificate saying that he has a net worth of 80 lakhs, 80, and in that 80 lakhs, he has not included the personal liabilities or personal guarantees which he has given to different banks and financial institutions. Along with that, he has submitted an MOU in which the investor has declared his net worth at 30.60 CR. So my question to you is, that there is no consortium between investor and the suspended director, that only that MOU is there. So can it be treated as a eligible resolution plan, given the fact that there is no document except that MOU, and that MOU is also a conditional document?
Now, they see there are two different aspects. One is the source of funds, and that is relevant for feasibility and viability, and the other is the eligibility criteria, which the committee of creditors have already decided. So the committee of creditors says that there has to be some particular net worth of a resolution applicant, so that has to be complied with first, and then the second stage would be the feasibility and viability. First threshold has to be crossed before we reach to the second threshold, that is the feasibility and viability. So in this case, a investor coming in and saying that he will invest 30 crores, that cannot make him a joint applicant, that cannot make him a consortium, because see, that is not the way the resolution plan was submitted at the first place. So therefore, I don't think that resolution plan is eligible. Although this is a question not related to the feasibility or viability. So we have answered, and now I think, Ankit, we need to close because it's already 12.
Yeah, thank you.
Thank you, Ji.
Thank you, sir. Thank you, everyone. Thank you so much for the wonderful session. And
Thank you.
as
Thank you
Anil
very
sir
much.
says, this is our way of learning. Thank you. Thank you.
Thank you.